Hi, Steve Hansen with Hansen IP Law. Hey, I want to talk to you today about how to get technical help for your business without losing your patent rights. I want to start out with a quiz. Let's say you have an employee, and that employee does some technical work and ends up developing a patentable invention. Who owns the rights to that patentable invention, the employee or the company? I'll wait. All right, time's up. Answer is the employee. Under U.S. law, whoever invents the patentable invention is the owner unless they have assigned their rights to somebody else. So if you don't have an assignment from that employee, the employee owns the invention. Now, there are some exceptions where an employee was specifically hired to invent, and if you don't have the ownership rights, the company may get what's called a shop right or a non-exclusive license, but you really want to own the patent rights. That's why you're developing the patentable invention. So if you have employees, ideally what you want them to do is to sign a present assignment of all future patent rights that may be developed in the course and scope of their employment to the company. Have them sign that right when they start, day one. But make it a present assignment, not just an agreement to assign in the future, but an actual present assignment. Then what you'd also do is, as they do develop inventions, you'd have them sign specific assignments for the individual patent applications. But if for some reason they refuse to do that later, you always have that initial assignment that you can rely on and you can record with the Patent and Trademark Office. The same thing is true with contractors. Just because you pay a contractor to do some work for you does not mean you own the rights to that work. Under patent law, it's the inventor, and that's the contractor if they are the ones who did the work and came up with the patentable invention. So again, what you want with a contractor is a present assignment of whatever they may develop in the course and scope of their employment, or not their retention, their engagement, because they're not employees. So you want to get that, and then again, you would have them sign specific assignment documents for individual patent applications once those are developed. But if they refuse to, for some reason, you always have that initial document with the present assignment language. And that's a very important point. You want to make sure it's a present assignment. There's a difference between that and an agreement to assign in the future. An agreement to assign in the future is a contract. It's not a transfer. So, if they refuse to honor an agreement to assign, then you're stuck with having to go file a breach of contract action and get a court order obligating them to sign an assignment. So you want a present assignment both for the employee and for the contractor. Now, there's a reason that this gets confused a lot. And I'll tell you what happened. I had a client come in here and he had a contractor agreement that he was relying on to assign patent rights to his company. And it had a provision in it called work for hire. And problem with that is work for hire is a copyright doctrine. It does not apply in patent law. You cannot rely on the work for hire doctrine to transfer patent rights. Under copyright law in the U.S., works created in the course and scope of employment belong to the owner, the copyrights do. But that is not true of patents. So, if you have employees, you have contractors, get a present assignment of future patent rights, and then have them sign individual assignments as they create individual patent applications while doing their work for you. Okay? Until next time, I'm Steve Hansen.